to our Zaremski Forum for today. The Zaremski Forums are funded by a law school graduate, Miles Zaremski, and his wife, Elena. Allows us to bring speakers to the law school and give talks, which typically are offered for continuing education credit, but because we had to do this very quickly in order to be able to address this topic that is, very much in the news, we aren't giving CLE credit for this, but Professor Jessie Hill has graciously agreed to give this talk very quickly. And her title is The Mess with Texas, What's Going On with Texas Abortion Law. So without more, please welcome Professor Hill.
Thank you. I am actually going to take my mask off because we're webcasting, and I think just to ensure the sound quality. So thanks, yeah. So reproductive rights are my area of specialty. I've been following the Texas situation very closely, and I thought it would be a good opportunity, actually at Professor Melman's suggestion, to talk to you all a little bit about what's been going on and to kind of unpack some of the stuff you might have been hearing about in the news. This is kind of as complex a case as they come. And so, I did not, because of the sort of short timeline, I have not had a chance to put together a PowerPoint or anything like that. So I'm going to just talk. I'm going to try to kind of lay out for you first what the Texas law says, what it actually does, and then talk about the lawsuits. There's one main one, although there have been a couple of other lawsuits filed, and what happened with those. And then spend a little time thinking about other approaches to this law and the problems it raises, and what the future might bring. And then I do want to leave time for Q&A, so I'm going to try to cover all of those topics relatively quickly because, like I said, this is super complex and folks probably will have questions no matter what. So, okay, so first of all, on the most basic level, the Texas law is a ban on abortions after a fetal heartbeat can be detected. Even heartbeat is a misnomer, really, because there's no heart. They're actually at this early stage, which is about 6 weeks of pregnancy. It's actually just sometimes referred to as a cardiac pole or fetal cardiac activity. There's an electrical signal that makes a noise that can be picked up on ultrasound. 6 weeks of pregnancy, by the way, they date pregnancy from your last menstrual period, but that means that you actually haven't conceived until you are, according to this measurement, considered 2 weeks pregnant. So 6 weeks of pregnancy is actually 4 weeks approximately after conception. So you're really only 4 weeks pregnant. So you may or may not even have missed a period at the 6 week point. So a lot of people don't know they're pregnant at 6 weeks. The only exception to this ban is for cases of medical emergencies that have to be documented and explained in the record, in the patient's record. Let me just start by saying this law is clearly unconstitutional under the existing framework. We don't have to go into too much depth about it. It is a law that bans abortion well before the fetus is considered viable, which Roe v. Wade and every case since then has taken for granted that you can't do that. So no one even really disagrees or has made any serious argument that this prohibition is constitutional under existing doctrine. Now we may talk about what does the Constitution really require, or what will the Supreme Court do when it has to decide this issue. That's a different question. But for now, lower courts, states, legislatures, everyone is bound by the current interpretation of the doctrine. Okay, so what happens? This law passes in Texas. Normally when an unconstitutional law passes, and there have been many other states, actually, including Ohio, that have passed laws banning abortion once the fetal heartbeat can be detected, which is, again, at this early point in pregnancy. Well, normally you have two options. If you're affected by the law, and that might be a patient, but it might also be a clinic, a physician who provides abortion, anyone who can be prosecuted under the law. normally you have two options. Either you can bring a lawsuit before the law actually takes effect and before it's enforced against you, and ask the court to enjoin the officials who are responsible for enforcing the law. You can ask them to issue an injunction to those officials telling them not to enforce the law. That's what you see a lot. That's what often happens. That's what happened with Ohio's heartbeat ban, and it's currently still blocked. It's tied up in litigation. And the other option, which for obvious reasons is way less appealing, is to go ahead and violate the law because you're pretty sure it's unconstitutional and it's going to be declared unconstitutional. And then when you're prosecuted or sued in court, you raise the defense that this can't be enforced against you because it violates the Constitution. Like I said, usually that route is not followed, although it has been sometimes, but usually it's not, because who wants to risk criminal penalties, civil penalties, whatever they might be, if you turn out to be wrong, during the pendency of the litigation, who wants to wait and get sued, all of that stuff. Okay, but this law in Texas is unique in that it is designed to foil both paths to getting constitutional review, so to getting declared unconstitutional. With the first path, where you would sue ahead of time before it goes into effect and before it's enforced, the law is designed to avoid that because there is no state official that is charged with its enforcement. There's no criminal penalties. There's no state medical board consequences for violating it. There's no connection to any. As a matter of fact, the law explicitly states that government officials cannot enforce this law. Only private parties. So the only way the law can be enforced is that any private party, and it's anyone in Texas, can bring a lawsuit and against any person who has aided and abetted an abortion, performed an abortion, or even intended to assist in a violation of the law. And they can get a judgment for a minimum of $10,000. That's the enforcement mechanism. So, but the key thing about this is because it's only private parties. Now remember, even though it's a constitutional challenge, it's still a lawsuit. You still have to bring it like you bring a lawsuit. And so if you're the clinic or abortion clinic, for example, and you want to get the law declared unconstitutional, you got to sue someone. You can't just sue Texas, okay? There's no, first of all, the state has sovereign immunity. Second, what is Texas? There's no just Texas, right? You can't sue every person in the state. You have to actually name a party that you're suing. And so with a private enforcement mechanism, the problem is there's no clear person to sue. Nobody has sued yet, right? The law wasn't even in effect yet. Who do we sue? There's no state official like the DA or district attorney or the attorney general or, the state medical board members or anything like that you can name. You don't know who's going to bring the lawsuit. Anyone might bring it or anyone might not. Can you sue every person in Texas? No. The answer is no, you can't. So, okay, so there's that. So, okay, well, what about just, this is an extraordinary case. What about just bring a test case, violate it, maybe violate it once and see what happens? Well, there's some challenges there. The way the law is written, first of all, $10,000 is nothing to sneeze at, right? It's a significant penalty. That's per abortion. But it's also any person in the entire state can sue you in any county they want, essentially, in their home county, in your home county, in the county where the offense occurs. So they get to kind of pick their court, really. And although if you pay out a judgment for $10,000, then you can't be sued again for that same abortion, right? So let's say you just perform one abortion in violation of the law, but you can until you've paid it out. So let's say you've been sued by one party, you can be sued by 1,000 people for the same one abortion that you do as a test case, and until you pay the judgment, you have to defend all those lawsuits. And so that's another problem, is that the mere costs of defending lawsuits, the logistical challenges, the time, all of that is designed to be a challenge. Like I said, it forbids aiding and abetting an abortion after the fetal heartbeat. The law even forbids intending to engage in a violation of the statute, which seems kind of crazy, but I think it's aimed at the idea that they want to enable testers to pick up the phone and call a clinic and say, I'm 12 weeks, I'm 13 weeks, I'm at some point where the heartbeat is going to be detectable, right? Can I have an abortion? And if they say, come on in, right, you probably have at least a prima facie case. There is, the law says that if one court declares the law unconstitutional, if that ruling is not binding on the court you bring a lawsuit in, then it's, you know, it's not necessarily going to help. You can't necessarily use that as a defense. The law says if you win your case, but later say Roe v. Wade is reversed by the Supreme Court, then you can be retroactively held liable. So even if they do this test case, even if they win, which I'll say a little bit more about, if the Supreme Court overturns Roe v. Wade and says that would have been constitutional, then the law says you can be retroactively liable. There's a 4-year statute of limitations. Finally, there's no ability for the defendants who are sued under this law to get attorney's fees, even if the case is frivolous. The law explicitly excludes that. And it also says that you have to pay the other side's attorney's fees unless you win every possible claim. Okay, so if the plaintiffs win at any, or if you sue to get the law enjoined and lose, you also have to pay. So if you bring the first kind of lawsuit, the pre-enforcement lawsuit, and lose, you have to pay the other side's attorney's fees. Okay, so lots of deterrence, right? Okay, so what happened? The clinics were faced with this law. Like many state laws, it was passed but had a 3-month period before it goes into effect. That's how it is in Ohio too. If Ohio passes a law, generally there's a 90-day period before the law takes effect. So normally that's the period of time when plaintiffs would bring lawsuits to challenge the law. Well, that's what happened in Texas. Various groups, abortion providers. Oh, I should say, by the way, the person who gets the abortion is not able to be sued. That's the only person you can't sue under this law. So anyone who helps them, any provider, anyone who pays for the abortion, even insurance companies can be sued, but not the patient. Okay. So there was one main lawsuit brought, which was a huge coalition of abortion providers, of abortion funds that help pay for abortions for people who can't afford them, other groups who advocate for abortion in Texas, tons of lawyers, Planned Parenthood, all kinds of groups in this lawsuit. The lead plaintiff was Whole Woman's Health. That's the name of the clinic, so we'll call it Whole Woman's Health. They came up with a strategy. It was a novel one. What they decided to do was to sue all of the state court judges in Texas that would be hearing these cases, and to sue the clerks who would be accepting the papers in these cases, and claim that the law is unconstitutional and ask the court to order them not to accept any of these lawsuits because the law was unconstitutional. This is really novel. This isn't normally how a constitutional case proceeds, and one of the challenges is that judges have all kinds of immunities under state and federal law. So, surprise, surprise, judges make the laws. They made the law that they are hard to sue. So it turns out judges are really tricky defendants. It wasn't a completely frivolous, lawsuit. It was it just looked to be an uphill battle from day one. They also sued one private individual, Markley Dixon, who is an attorney in Texas who was one of the masterminds. He and this other former Texas Attorney General, Jonathan Mitchell, who were the masterminds behind this Texas law. And he had been going around saying, as soon as this law passes, I'm going to sue some abortion providers. If you want to sue some clinics, contact me. I'll represent you. I want to enforce this law. Can't wait. Okay. So they sued him to prevent him from suing them, right? They brought this suit in federal court on the theory that, as you may or may not, depending on where you are in your law school career, you may, and we can talk a little bit more about the distinction between state courts and federal courts, but there's a general perception that federal courts are more friendly, are more accepting of federal constitutional claims than state courts are. They also often move quicker, and they often are, again, perceived, it's not true across the board, but in general, it's perceived to have a higher quality of judging. So they brought this suit in federal court, asked the federal court to enjoin the state courts. Now this is still pretty rushed because it took them a while to put the lawsuit together. It's a big, complex lawsuit. And then there were all these arguments. They wanted to name the judges as a class action because there are like probably thousands of them in Texas. It's a big state. It has 200 and something counties. And so there are all these procedural complexities. Basically, the judge lays out a briefing schedule, the trial judge, and says, okay, we're going to have a hearing on August 31st because I know this law goes into effect on September 1st, knowing that he had to make a decision by then. Essentially, there's all this procedural wrangling. As a matter of fact, shortly before the hearing on whether or not the law was unconstitutional and should be enjoined, the defendants, the judges, and their attorneys said, we need to have a 3-day hearing with 11 witnesses, and we want to cross-examine them and things like that, which, again, was insane. It was just a sort of game of delay. There's no need for witnesses in a case like this. Okay, in any case, another thing they did is they claimed that they had sovereign immunity. And like I said, judges do have a plausible claim to this. It's hard to sue judges. They get to claim all these kinds of immunities. They said this case should be dismissed because we have sovereign immunity. And the trial court said, no, you don't, and declined to dismiss the case. And then, I think it was about a week before the hearing was scheduled, those defendants, the judges, actually all the defendants, appealed that ruling up to the Fifth Circuit Court of Appeals. So if it was sovereign immunity, the case would have had to be dismissed completely. Well, there's a rule that normally when you have what are called interlocutory rulings, you can't appeal them immediately. You have to wait until the case is over. Like unless you have a final judgment, which they didn't, you have to just wait till the case is over. But because sovereign immunity is kind of special, because it means that if you have sovereign immunity, you can't even be sued, there's a rule that you can appeal those rulings immediately. And as a matter of fact, once you appeal a ruling, that divests the district court, the trial court, of jurisdiction over everything related to that ruling, because now it's in front of the appeals court. So the district court can't proceed on that. So they did this like a couple days before the hearing, right? Very clever, get in front of the appeals court. And the plaintiffs say, well, first of all, please let the lower court proceedings go forward, but if you're not going to do that, at least let the lower court proceedings go forward as to that private individual. He doesn't have sovereign immunity, the guy who's been running around saying he wants to sue abortion providers. So why can't the case go forward as to him? Which is pretty clever, again, because if it did, then they could still get a ruling that the law was unconstitutional, right? They wouldn't be enjoining all those judges yet, but at least there'd be a ruling on the books saying this law is unconstitutional, enforce it at your own risk. Well, the Fifth Circuit issued something called an administrative stay, which means it just stopped the whole case in its tracks without any opinion, without giving any reasoning. Normally, an administrative stay is something courts might use in a situation where they need to stop things temporarily to figure out what their ruling should be, but they don't have time to write a whole opinion or read the briefing. So they put an administrative stay in place, and they told the district court to cancel the hearing that was scheduled for the day before the effective date. At this point, it's like Sunday, August 29th or something like that, yeah. And the clinics rush to the U.S. Supreme Court, file emergency papers asking the Supreme Court to issue an injunction to put the law on hold and let the case continue to be litigated, but not allow the law to be enforced. And that was the decision that the Supreme Court, first of all, didn't act on initially, right, on the effective date of September 1, just kind of had briefing in front of it, but didn't rule. And then the next day, on September 2nd, the Supreme Court did rule 5-4 that the case, that they would not issue the injunction pending appeal. So in other words, they would not step in and block the law. The law could go into effect while the litigation continues. Chief Justice John Roberts had actually joined with the liberals to make the 4 in that decision. So what does that mean? And part of why, actually, well, let me just say that the decision, which was very short, it was one long paragraph, basically, just said, it didn't say this law is constitutional. It explicitly said we are not deciding whether this law is constitutional. It said there's procedural complexities here, and we don't feel that the plaintiffs had made their case sufficiently that this case can proceed, basically on the sovereign immunity issue. Now, why they haven't let the case go forward against this private individual, I mean, he's got a lot of arguments. I personally don't think much of them. He's basically said, what? I'm not going to sue them. I never intended to sue them. What I intended was for them to comply, which is exactly what they're doing. So to our knowledge, to my knowledge, all of the providers in Texas, abortion providers, are either complying and only providing abortions up to 6 weeks of pregnancy, or there might have, I believe there are some that have stopped providing abortions at all. But just, I mean, to be clear, that is not a viable situation. Like, they're not going to be able to stay open. I mean, maybe Planned Parenthood can, because Planned Parenthood provides a lot of other services, but many clinics provide only abortions if they provide abortions, and they are not going to be able to continue because there's so few people who are going to be able to take advantage of the pre-6 week time period. There are other lawsuits that have been going forward, and you might have, if you're really following this, you might have read about that. So there are some Planned Parenthoods and some other groups have gone into court, in state court in Texas, and sued Texas Right to Life in individual cases, and said this law is unconstitutional. Texas Right to Life has indicated it wants to bring lawsuits, especially because it opened up a website for people to report tips on people who might be violating the law. So it had opened up this like tip line. And so there seemed to be enough reason to think Right to Life wanted to be involved in bringing lawsuits. So they sued Right to Life and said, you know, please stop them from suing us. And they have been successful in getting at least temporary orders preventing Right to Life to sue them. But these two were kind of emergency orders. They haven't played out the merits of the case yet. And in a way, they're just kind of symbolic relief at this stage because, you know, so Right to Life can't sue you, but anybody else can. And, or maybe Right to Life's members also would be included within the injunction, but anybody else can, and surely there are people out there who would risk, you know, would sue you still. And so I don't think providers have decided to, you know, flout this law just because of getting those injunctions. Also, it only protects the people who have brought the lawsuits. It only affects the people who have the cases in state court. Okay. All right, so that's basically where things are right now. Things are now in front of the Fifth Circuit, and the case will move ahead on whatever schedule the Fifth Circuit sets for the case to move ahead on appeal. And right now, the main issue is this sovereign immunity issue. The case, I'll say a little bit about what might happen next, and then I want to throw out there a few other theories about this situation that people have suggested could be used maybe by the plaintiffs. So right now, I think that case is going to proceed in front of the Fifth Circuit, but that is like going to take forever to resolve, because even if it's on an expedited schedule, it's only on sovereign immunity. It has to go back down to the trial court. Things have to work out on the merits there. It's not clear what value even that injunction will be. Meanwhile, because, and this is what I was going to mention earlier, there is another case, as you may or may not know, pending in front of the U.S. Supreme Court right now out of Mississippi. And this case deals with a law that bans abortion at 15 weeks. Also not constitutional, also well before viability, so it's a pretty bright line. But the Supreme Court decided to hear this challenge to this law, which indicates, and decided this term, okay, so probably will be decided by the end of June 2022, where it may be planning to overturn Roe v. Wade. I mean, we don't know for sure, but it is, I think that the smart money is on the idea that the court is either going to overturn Roe v. Wade, the right to abortion, constitutional right to abortion, or that it's going to significantly cut back on it. So all of this stuff is going on in the shadow of what the court is going to do in a matter of 9 months, 8 months, whatever it is, that are also going to affect the outcome of these cases. And this Texas law that may looks blatantly unconstitutional may be kind of constitutional as of June. And remember, it has retroactive effects. Those state court cases that I mentioned, maybe they will make their way up to the Texas Supreme Court eventually, and then from there to the U.S. Supreme Court. And so the court, the U.S. Supreme Court could end up striking it down on the merits. The Texas state courts, by and large, not all of them, but certainly the Texas Supreme Court has not been particularly generous toward abortion rights, typically, and so it's a scary place to be in this case. But if you get in front of the U.S. Supreme Court, maybe the U.S. Supreme Court will strike it down. I think, my own view of this is that this is the way this law is written is just such an affront to judicial authority and to the federal courts in particular, but to the authority of the Supreme Court, to the role of the courts in our system, that I doubt even the U.S. Supreme Court will stand for this. Even though, again, we have a majority that is not big fans of abortion rights on that court. I think ultimately it doesn't stand up. I think ultimately it doesn't stand up too because it doesn't take, Oliver Wendell Holmes to tell you that if the court upholds this law, next thing that will happen is blue states will be passing gun control laws that are designed exactly like this, right? And laws outlawing anti-abortion speech, right? And pretty soon the courts won't have any role at all. I mean, the Constitution will just be completely undermined, I suspect. That's my amateur prognostication. Okay. But in the meantime, access to abortion is absolutely decimated in Texas, and other states are probably going to follow suit, including this one. Okay. So we can talk more about that if you want. But I just want to say something about some other theories that are floating out there. A lot of people are putting theories out there. Our U.S. Attorney General, Merrick Garland, suggested he might use a federal law called FACE, the Freedom of Access to Clinic Entrances Act, to prosecute people who try to use this law. That law forbids using force or intimidation to hinder access to abortion clinics. It's obviously a law that's aimed at violent protests in front of clinics and violent actions to shut down clinics. It really seems like a stretch. It seemed more rhetoric to me than reality. That law, it defines intimidation very narrowly to include only putting people in fear of physical harm. It's really very concerned with physical threats and violence. So, I don't know. Also, there's a very prominent constitutional scholar, Lawrence Tribe, who suggested numerous theories, actually, that could be used. So one thing he has said is that this law violates a principle that says that you essentially cannot delegate legal authority over individuals to other private individuals. So give basically the coercive power of the state, but to private individuals. And that's exactly what this law does. So that principle partly traces to a 1982, I want to say, case that Tribe himself litigated in Cambridge, Massachusetts. He's a professor at Harvard Law School. He was actually my constitutional law professor, where that was called Larkin v. Grendel's Den. Grendel's Den was a bar that wanted to get a liquor license, but there was a Cambridge city ordinance that that allowed churches to veto issuance of a liquor license to any business within like 500 feet or something. And Grendel's Den was within 500 feet of this church, and the church said, no, we don't want you to have a liquor license. We don't like booze. And so the court struck this down and basically said, partly because, of course, it empowered religious entities in this way. It basically gave the state's power to a religious organization, so violating the separation of church and state. But there actually is a whole body of case law that also suggests that you just can't give this kind of power over others' constitutional rights, over their property rights, to third parties. I think it is a good theory about why this law is unconstitutional, but it doesn't tell us who you sue to carry out this theory. It's the same problem as the plaintiffs are having. Yes, it's unconstitutional, but there's still nobody to sue when you want to vindicate this constitutional theory. Again, maybe it's something that can be used defensively if someone is sued, and maybe even if Roe v. Wade is overturned, maybe it still works. So maybe that's an advantage, but I'm not sure that gets us anywhere. For now, maybe it does. Tribe has also suggested, the same professor has suggested that two Reconstruction era civil rights laws, 18 U.S.C. section 241 and 18 U.S.C. section 242, which forbid acting under color of law to deprive someone of their constitutional rights, or conspiring with other people to deprive someone of their constitutional rights, that those could be used in this case, but those are criminal laws, so there would have to be a federal criminal prosecution of anyone who tried to use the Texas law, basically, who tried to bring a lawsuit under the Texas law. And there might be some technical legal problems with applying those here, but I think it's actually, again, another pretty smart theory, except that it depends on the U.S. Attorney General or the U.S. attorneys to be willing to enforce this law, to try to bring these criminal cases in front of a jury in Texas. There's a lot of risk with that. However, maybe just the suggestion of this would deter some plaintiffs from bringing these lawsuits. So that's another possibility. Finally, I think that there are other defenses. It's possible that most of these plaintiffs who would think about bringing a lawsuit under the Texas law to get, against an abortion provider, that they don't have standing. And those of you who are in constitutional law or have maybe already took it may know that you have to have some injury unique to yourself or to a group of people that allow you to bring a lawsuit normally. The problem is that the Texas state courts have slightly different standing rules than the federal courts, and these cases would be brought in the state courts. So maybe that works, but again, maybe it doesn't. Finally, one last theory is that if you get sued in state court, again, the Texas state courts may be very hostile, and there's every reason to think that a plaintiff might seek out a particular judge or a particular county where the courts are particularly hostile to abortion providers, for example. You might be able to then run into federal court and sue to enjoin, to block the state court lawsuit. Normally, federal courts won't do that sort of thing, but in extraordinary cases, they can. So that's another possibility. But like I said, I just want to end on sort of the practical note, and also, and I'm going to just stop talking in a minute here, and also on an Ohio note. So on a practical note, again, decimating abortion access, it's going to be worse for the people who can't easily get out of state, right? Can't take time off to travel, who are already, have difficult access to healthcare as it is. So that's a huge issue. Right now, I think some of the clinics are operating in the hopes that there will be a solution. So even the ones that are open now are probably going to close pretty soon if they don't get some sort of legal relief. So it's really, really bad. And there is, like I said, every reason to think that if this works, it's going to spread to other states. And I would think Ohio is probably one of the next on the list, honestly. We have a legislature that has been extremely aggressive on abortion rights, and some of you may have even aggressive against abortion rights. And some of you may have heard that there was a municipality, a suburb outside of Cincinnati called Lebanon, Ohio, that actually passed a law banning abortion in the city of Lebanon this summer. And there's no abortion provider in Lebanon, and it doesn't really apply outside of Lebanon. So, the practical impact of the law is maybe not great, but the law is very similar. Not identical. It actually does have criminal provisions, but it's very similar to the Texas law, and we know that the folks who were writing the Texas law had actually come up to Lebanon, Ohio, and consulted and talked with the folks in Lebanon and offered to defend the statute if it's challenged and so on. So that they are actually the same people who are kicking around in Ohio as were behind the Texas law. So I think, again, there's every reason to think that Ohio might be next, or one of the next ones. Okay, that was like so much. I talked for like 35, 40 minutes straight about this law, and I feel like there's so many moving parts. So I'm gonna stop and see if you're just massively confused, if you have questions, if you have any novel legal theories you want to put out there, because we could use them. Anything. No.
So if you have a question, please raise your hand and we'll give you a microphone. Ask a question. Yeah.
Can you go into the Texas state requirements for standing and how that differs from the federal?
Yeah, okay, so I actually am not an expert in Texas law, so I'm not super familiar. My understanding from folks who are is that so in federal court, you basically, among other things, have to show that you are particularly injured by this law, right? And so a law that just lets anyone sue because an abortion happened is like a quintessential example of something where there would not be standing in federal courts. However, because that, I'm just gonna go take a step back and say, because that requirement derives from Article 3 of the Constitution, which talks about the federal judicial power, it only applies in federal court. And so states are at liberty to have their own standing rules in their state courts. And again, these lawsuits were meant to be brought in Texas state courts. And so my understanding is that it's a bit of a morass. It's not super clear, but that there are cases in Texas suggesting that that the Texas legislature can grant standing to anyone if they want. So that normally the standing rules would apply unless the law says basically anyone can sue, or this broader group of people can sue. And then there have been decisions suggesting that that's okay and that is sufficient for standing in Texas state court. But again, I don't want to put myself out there as knowing a lot about Texas standing law, because I don't. It's just what I've understood from other conversations. Oh, I'll let Patty call it,
yeah. So I'm wondering, from a litigation standpoint, what would be the prima facie evidence that's necessary to prove the case, and then also who would have access to that evidence, and what position would that put patients into?
Right. So that's a good point, because it's easy in these conversations to lose sight of the fact that a couple of things in the favor of the clinics here. One, you still have to get a lawyer, you still have to pay court costs, you still have to go to court, and you still have to win your case, right? So you do have to prove a violation of the law is happening, just like any lawsuit, right? Enough to convince a reasonable trier of fact, by a preponderance of the evidence, that this law was violated. So, it really depends, right? The problem is if you called the abortion, the example I gave, where maybe you call an abortion clinic and they say, come on in, we'll see you if you're further along. Maybe that's enough, certainly, to file a lawsuit, right? And then you get discovery, right? And then you can ask for records potentially, right? Or at least you're going to have to fight over it. So, I mean, again, maybe you, or maybe you know, right? Maybe someone told you that their partner, that their sibling, that their grandchild, whatever, had an abortion, right? So I think if someone is violating the law, right? If they're not, you can still try, right? A plaintiff can still try and bring a lawsuit. Again, this law kind of seems to welcome frivolous lawsuits because it essentially seems to put all the potential penalties only on the side of the clinics. But, you know, I think you're less likely to go to that trouble. And so we may not see many lawsuits because all the clinics are saying that they're compliant with this provision. But yeah, and I mean, you know, ultimately, like, Texas has a requirement that you have to do an ultrasound, you have to, like, chart all this information. I mean, I assume that they would be able to get access to whatever information there might be in the medical records once they got into discovery, if there was discovery. I mean, the other thing to just keep in mind is, right, like, you don't pay out a judgment until the end, right, until the case is over, generally. I mean, if you appeal, you may have to post bond and things like that, but it's not like as soon as you're sued, you have to pay it out, right? So there is still room to, like, win a case. But I think the real sort of danger here is the interorum effect, as we might say, of just the possibility of being subject to and having to defend, like, literally thousands of lawsuits, potentially, right, if you did violate the law.
I guess this is more of a curious question, but when you mentioned the enactment of FACE or trying to get that in, could you argue that the fear of physical harm would also reference women being forced to carry, or a person being forced to carry a child to term, because that would in some way cause harm to the body?
So that's interesting. I mean, I think that you have to be trying to obstruct clinic access to clinics by putting someone in fear of physical harm. So, I mean, I'm not sure that that works, just because, like, you know, the person, certainly the woman is ultimately in fear of physical harm if we define it that way, but I'm not sure that that's the thing that's threatening clinic access, right? It's the lawsuits against the providers that's threatening the access. So, I mean, I think the other danger, and, you know, not to, like, dismiss novel theories, but with novel theories under a statute like FACE, I mean, it's a criminal law. Again, you've got to get, like, the U.S. attorney to decide to use that. You've got to get a jury to buy it. You've got to get a judge to, you know, let it go forward. So, you know, it's a gamble anyway. But yeah, yeah, it's an interesting possibility, though, and certainly, again, could deter people from bringing these lawsuits, you know. Yeah, but interesting thought.
So I have a question. The aiding and abetting violation of this law, does that, so if say an abortion rights group in Oklahoma wanted to, facilitate access to abortion for people in Texas and Oklahoma, can they be targeted? I mean, can Texas get jurisdiction over them? How does that work?
So that is another really interesting question. And my understanding, again, from having talked to, like, attorneys who have been litigating this case and involved in it and done the research, I'm not going to claim expertise in Texas law firsthand, but my understanding is that Texas law has a strong presumption against extraterritorial application. So a strong presumption against their criminal law applying outside the borders of Texas. So in other words, anything that Oklahoma group does in Oklahoma, probably not. And Texas is probably not inclined to prosecute that anyway. But, you know, if they send money to someone in Texas or do something in Texas, then it becomes a question of, you know, can they be subject to, as you might recall from civil procedure, personal jurisdiction in Texas, right? And then they, presumably, if they set foot in Texas, maybe also they could be arrested, or not arrested, but served with papers and sued in Texas. So
if someone in Texas use the webcast of this talk, can you and I be sued in Texas?
Well, okay, so the law, I will say this, the law has provision that I consider sensible, which is that it excludes First Amendment activity from subjecting anyone to liability. Although what that means, I don't know, you can take a whole semester-long course on what that means. And so there's actually a Supreme Court lawsuit you may read if you take that course, in which the Supreme Court found that the First Amendment itself is unconstitutionally vague. So you cannot just say, like, don't violate the First Amendment. So it's hard to know what that means, but probably our activity would be protected by that provision under the statute. But yeah.
Seeing no other hands, I have another question.
Sure.
Which is, okay, so anticipating the Supreme Court overturning Roe v. Wade in this term, what steps, if any, are being taken to prevent that or to respond to that? So, for example, is court packing still a viable strategy? That I haven't heard a word about it in a long time to try to, deal with that?
Right. I mean, that's one possibility. I think that it's a lot of those possibilities seem to be dead in the water because of the filibuster and the fact that although Democrats have the Senate majority, Joe Manchin, I don't think is pro-choice, and so I don't think he supports abortion rights, and I don't think he would go with court packing or overturning the filibuster for something like this. I mean, I will say there has been a degree of political outcry over this that I think may have taken some folks by surprise. I think, the extent to which there was a reaction to the Supreme Court decision not to step in, public reaction. I think this is not fading from the public eye anytime soon. I could be wrong, but, sure, constitutional amendment. You could get protections at your state level, go show up at the legislature, contact your legislators, tell them you don't, if that's your view, that you do not want them to adopt a law like this. There may still be, or just that you don't want that, that you want them to protect abortion rights. So if the Supreme Court overturns Roe v. Wade, which provided federal constitutional protection for abortion rights across the country, it likely will just say that states get to decide this issue now. It's not a constitutional question. So there's still work that can be done at the state level. Individual states can and probably will protect abortion rights, some of them, just not all of them, and it'll be to different degrees. Oh, there's some questions here.
So this is a little bit of a stretch, and I don't know if it's applicable, but the UN considers access to abortion a human right. Mm-hmm. So at what point could we say this is a violation of human rights in our country, and then try to, I guess, enforce it from us being a member of the UN?
Right. So I'm trying to think of how it would play out because, there are a couple of caveats. One is that, U.S. courts are not always eager, let's say, to apply international human rights law anyway, even though you're correct, it's binding on the U.S. But yeah, I think you would have to, and if you're going to bring that claim within a U.S. court, you face that obstacle plus, again, these problems of who do you sue. Although maybe you can sue, I don't know. Maybe maybe there are different sovereign immunity arguments available there, because I don't know that, like, human rights litigation piece of things as well. But yeah, and then I think if you're going to sue an international tribunal, obviously that's a whole other level of enforcement difficulties and things like that. But yeah, it's an interesting thought. Yeah, no, I think everything is a stretch right now, so there's no shame in having legal arguments that feel like a stretch. It's all a stretch, yeah.
I saw a quick news alert about how the Department of Justice spoke out and said that they would protect women's rights to abortion. Could you just go into how that would even work?
Yeah, it's not clear what they mean. I think it was, more of a symbolic statement than anything else. Again, maybe because the Attorney General did make that comment about FACE that we were talking about before, maybe investigating whether FACE could be used in this context. Maybe also it could have been those, like, remember I mentioned those civil rights laws that that Professor Tribe had mentioned around like conspiracy to strip someone of their constitutional rights. You know, the federal government can enforce those, the Department of Justice can enforce those, so maybe they're considering threatening prosecutions. I mean, I think that those are also really good. Well, I mean, there could be some technical issues, but I think that they're plausible theories. So maybe they threaten. But the problem with that again is like, then somebody has to bring the lawsuit. And what's happening right now is everybody's afraid to is so chilled from, you know, providing services beyond 6 weeks that they're afraid to even violate the law. And so then you violate the law and you get sued, and then the federal government comes and prosecutes the person that sued you. I mean, you know, unless it really deters everyone, it's not a great remedy to protect abortion rights. So I don't know what they are planning to do. I mean, I guess the other thing, and this goes back to Professor Melman's question too, is there could be a federal law, right? And there's been calls for that, for Congress to pass a law that codifies Roe v. Wade. It doesn't look like a law like that would have much opportunity to pass, again, given the political realities right now in Congress, but there could be maybe enough outcry that it would. And then that, of course, then that law would get challenged as being beyond Congress's power to enact, and it would go in front of this U.S. Supreme Court, and we would have to see, you know, what they decided. But that's another direction. That's not DOJ, that's Congress, but that's another level at which the federal government could get involved.
Other questions? Yes. That'll be our last question.
Sure.
In terms of going back to the federal government, I know that there were certain things throughout the last year and a half that were executive orders that became acts, or were, would this be something that could be like an executive order? So I know theoretically Biden is pro-choice.
Right. Yeah, I mean, again, the problem with executive orders is that they have to be within both within the authority of the federal government, and if it's an executive order, it has to be like within the president's ability to do that, right? And so it becomes a question of, I mean, it does become a question of what does that look like? What are in terms of the details of that? Are there things that are within the president's authority to enact as an executive official, right? And I mean, that the sort of, you know, like the Supreme Court just struck down his attempt to extend the eviction moratorium, right? Well, the CDC's, but the executive branch attempt. So yeah, maybe, I mean, maybe there would be things that are kind of attached to expenditure of federal funds, for example, or interpretations of specific agency requirements that could be put on the Texas legislature. But, you know, again, all of those things are subject to their own set of constitutional constraints. So it's an interesting thought. And I probably haven't played that out enough, but yeah.
No national defense of the state of Texas.
right.
Welcome
Right.
Mexico. All right, well, thank you very much, Professor Hill. And if you have any questions, perhaps you can stay for a few moments. We'll be having additional Zaremski talks. You'll hear more about them as the semester progresses. So, thank you very much.
Thank you.